Greetings and salutations, my fellow sovereigns. This is the Vocational Science Freedom Saturday Night Civics and Sovereignty class. And tonight we will be covering a treatise on the American law of administration. So I'm going to walk everyone through how to go through a treatise in general. And specifically, we're going to be looking at how the system works, meaning the totality of what they're doing in America to administer all of our estates. We're going to figure this out and learn this by going through a treatise, studying vocabulary words, learning what these things mean, and seeing the connections with what they're doing in their Roman civil law system. And if you'd like to join the Vocational Science Freedom Gilded server and come hang out with us in class, you can do so by going to the Vocational Science Freedom YouTube page and clicking on the banner in the upper right-hand corner where it says VSOF Gilded Server. And the link for this server is also in all of the show notes on both Odyssey and YouTube for all of the classes. So, yes, and if you want the simple URL, it is simply gilded.gg/VSOF. So I've got the live stream up and running. If anyone like to watch that, that's just fine. If you want to just be a fly on the wall, you're happy to do so. Or if you want to join in class, you can join in on Gilded. All right, so I gave links in chat for the mega folder. And if you'd like to open that up and download the treatise, there's two treatises that are in there. I'm just going to be going through the first one tonight. And it's called A Treatise on the American Law of Administration, Volume 1. There's Volume 1 and Volume 2 in the folder. So let's pull up Volume 1, and I'm going to scroll up to the top. I believe this was I think it was 1895, I think. I don't know if there's a date in here. Okay, 1899, that's what it is. Okay, so, and these are the treatises at this time of history. These are the treatises that you want to pick up and use, because the ones around the end of the 1800s, very early 1900s, are the treatises that you want to use, because everything that comes basically after, or gets into like the 1920s and 1930s, and particularly anything after 1930, that's when they brought in the New Deal, and they were pushing and pushing and pushing to get rid of the common law. And so, but the treatises that are before that, around this era of time, are the ones that you want to pick up and read if you want to actually learn the true law, and before it was butchered and destroyed by attorneys who wanted nothing more than to take over this entire country. So as far as table of contents is concerned, this is going to be fairly lengthy, but we're probably only going to get to maybe a bit of chapter 2 tonight, probably. Because I'm going to be going back and forth between, I'll stop every once in a while and go through vocabulary words. So I'm going to be looking at vocabulary words in Bouvier's. And if you want to download Bouvier's, it's on the VSOF online library, the mega library. So those that are VSOF members, you can download all of Bouvier's in either the VSOF online library for the Gilded is the mega folder. And it's on the Gilded server, particularly for the dictionaries. So anybody can download the dictionaries there, and the links are in the chat. I'm not going to go scan for them now, but anyway, I can post them later after class. So we'll be going back and forth through Bouvier's and jumping back and forth from the treatise. So I will expand this out so it looks better for the stream. I'll keep the chat open in case anybody needs to post anything or has any questions while we're moving along here. So let me get down to, I believe it was page 180, I think it was 187. Wait, hold on. All right, so A Treatise on the American Law of Administration. Introduction, Chapter 1. The acquisition of property. My property is that which is mine. Period. Thank you. That only is mine which I acquire, hold, and dispose of by my will. This is why it's so important to understand the fact that they have stolen your will. They have stolen our wills through the presumption of death, infancy, and, in some cases, lunacy, which this treatise will all touch on. It'll touch on all three of those presumptions and when they come into existence and how the courts use them against us. Right? But this is the point. They have stolen our will. And through this treatise, you're going to understand that the word will does not just mean a testamentary will, meaning as in one's last will and testament. That's just one's last will and testament, the last thing that they will to be done. But your will is being stolen, the present. Whatever you will to be done is what is being stolen from all of us by the attorney in private, for-profit courts that are not of record. So I'll continue. It is my will which determines the acquisition of a thing by me, whether originally by reducing to possession and thus making my property that which was no one's property before, or by contract, by which a thing becomes mine through the concurrence of my will with that of its former owner. Since I cannot rightfully acquire the property of another without his consent, that is, without his free will. It is obvious that the will of the original owner is a necessary element in my ownership, and in the ownership of anyone who may lawfully acquire it after me, and remains operative until the property has lost its character as such by voluntary abandonment. And yes, abandonment we'll get into as well. Like how the mothers and fathers abandoned their children at the foundling hospitals, right? That's the aspect of abandonment, and that's a problem. But to continue. By my own free will, I may abandon my property, whereupon it ceases to be such, and relapse into the condition of res nullius, subject to become property by the sole will of any person who acquires it. So, this is what's called and referred to as abandoned property rights. And if anybody's watched the movie Good Will Hunting, you might remember that scene when he's in the court and the judge says, "Oh, well, you argued your way out of stealing a car in some, a few years ago because you argued some case of abandoned property rights." Right? So if someone doesn't use a thing and it's just sitting there for a long extended period of time, someone else can come along and take it. That's an aspect of free property rights. And you can even do this with land and with houses. There's a different way to do that, but it's basically adverse possession. Somebody abandons a house, no one's paying taxes on it. No one in their family has come to take care of it. They might be the last of their line, or maybe their children are in different countries and no one cares anymore. And the house just sits there. Well, what can you do? Well, you can go to the county. The Roman civil law way to do it would be to go to the county and start paying the property taxes on it, and then go to the house and just start bettering the house and go live in it. That's basically adverse possession. And that's lawful because it's an aspect of free property rights. Nothing is meant to waste. That's also an aspect of laws. Things should not be allowed to be wasted or go to waste. But okay, so that's just little aspect of that I just want to throw in there. Okay, so subsection 2. Tenure and use of property, it's lost by non-user. I hold or use a thing which is mine at will. Matter is unfree, i.e., it has no will. It does not belong to itself. Neither right nor duty can be predicated of a mere thing. Its quality is to offer resistance. It is therefore negative to my will. My will, in realizing itself, overcomes this resistance and subjects the thing to its purposes, changing its form, destroying, consuming it. That which is mine is thus a part of my personality of me, insofar as its end and purpose of existence is the satisfaction, the realization of my will. and to serve it for its purpose as my bodily limbs serve me. Will, then, is the essence of property. I'm going to read that again because it's extremely important to understand. Will, then, is the essence of property. When someone else takes away your will, they take away your property. And in a more extreme sense, when someone takes away your will by force, they have taken away your liberty. That's called kidnapping. But you see the connection. All right, to continue. Without it, there is none. Meaning without will, there cannot be property. Hence, that from which I have withdrawn my will, which I have abandoned, ceases to be my property and becomes, as we have seen, res nullius, the appropriation of which by another is no violation of my right because it is no collision with my will, because your will is no longer in full force and effect over the thing. You've abandoned it by your own action. If, then, I wish to preserve my property, or, which is the same in effect, my right to it, I must indicate in some way perceptible to others that it is still subject to my will. This is the reason why we file the Vocational Science of Freedom Status Doc set. We are saying on the public record, we are not abandoning our estate. We are claiming our estate, and it is our will that we do so. And that's why all of the Vocational Science Freedom Status Docs are a continuation of your will. That's how I wrote them. So it is in accordance with law, the very law that we're reading. And yes, you can use treatises of law as authority. Attorneys don't do it very often, but you certainly should do it when you are thinking about the creation of an instrument, deed, notice, whatever, declaration, whatever you might be writing. You absolutely want to use a treatise as your foundational understanding of what you're doing. And as you can see, the Vocational Science Freedom Status Doc set is in accordance with law. It is a continuation of our will to say, no, we do not consent to any administration of our estate because we have not abandoned it. We are not an infant. We are not a lunatic. And all those three things we'll get to later, which this treatise will cover. But to continue. So I'll just reread it here. Okay. If, then, I wish to preserve my property or, which is the same in effect, my right to it, I must indicate in some way perceptible to others that it is still subject to my will. Otherwise, I may be understood as having abandoned it. To avoid collisions arising out of a misinterpretation of my relation to a thing, a definite period is fixed by custom or law, within which my will is presumed to attach to it. If I permit this period to expire without using the thing or indicating in some tangible way that it continues to be mine, basically keeping it in possession, laying upon it, or in some way exercising ownership over it, its abandonment is presumed. Okay, so the abandonment is by what? Presumption. So it's presumed that you abandoned it. And my right to it is lost by prescription, my ownership barred by limitation. So that's where you get this from. That's where you get the use of the presumption of abandonment. And if you'd like to learn far more about all of the ways that the attorney uses all of the presumptions against you, I highly suggest that you go and listen to the rebuttable presumptions class. It's on the VSOF YouTube, and it's on the VSOF on Odyssey. It's rebuttable presumptions: how tyrants and black robe priests
welcome everyone to
enslave the world. Sorry, I didn't mean to start it, but there's a playlist. It was an all-day class, and I cover all of the presumptions, how they were created. I go back in the history of law, and show everyone what's going on, how they're using presumptions to administer our estates. So I highly suggest that everyone do that. If you've not yet watched this, I will copy the link and drop it into chat real quick, just for anybody that wants to watch it later, and get back to the treatise. So, all right. So now we're down to alienability of property, and I'm going to highlight this one as well. In like manner, I may relinquish my property to another, either by freely giving it or exchanging it for other property. We have already seen that property acquired from another can become such only by the will of the former owner. So anything that is taken from you, which is against your will, is called theft. And when you really break everything down, and first time I heard this, and I don't know if Mark Passio came up with this, but the way he broke it down was absolutely correct. Mark Passio explains that every single crime can be broken down to some aspect of theft. And also, I would continue with that aspect and say that all crimes can be broken down to the violation of one's will, is another way to say it. But the way Mark describes it is, take example, what is rape? Rape is the taking of a body that does not belong to you. What is trespass? Trespass is invading someone's abode or exceeding your jurisdiction by going onto someone's land that does not belong to you. That plain out theft is obvious. You're stealing property that does not belong to you against the will of another. So when you think about that, what is the perfect system that the Luciferian Khazarian mob attorneys could create that would allow them to do anything that they wanted? It would be a system that takes everyone's will without you even knowing it. That would be the perfect system of control and of theft. And what do we have? We have that exact perfect system running right now. Roughshod over our republic, over our substantive rights, over all the things which we hold dear and have been willed to us or given to us by trust through body politic, as in the manner of the Constitution of the United States of America, each and every original state constitution, the Declaration of Independence, the Articles of Confederation, and going all the way back to the Magna Carta. These are these things that come through us through trust, through body politic, of which we say that we are the heir to. In fact, the founding fathers referred to themselves as the heirs of liberty before they ever came around with the later terms of, say, being an American citizen. Right? That term didn't even exist in law yet. But what they did call themselves were the heirs of liberty. And where did that come from? It came from the Magna Carta. So, all right, back to this. Okay, so alienability of property. All right, so we have already seen, okay, so I read that. Okay, so my donee, as well as my vendee, holds the property given or sold by the concurrence of my will with his own. It must be my will, and that the donee shall take, and his that he will receive. Because you can't, now this is an aspect of saying you can't force someone to take something, right? You cannot be forced to take a benefit. You can abstain. You can say, I don't really want that thing. So you cannot be forced to take something, which is basically what they do to everyone in these courts. They force you to take a benefit, and that benefit is going to jail. But again, he acquires by me the gift, and my will to relinquish, and that he, the vendee, shall hold the property I sell or barter, and his to relinquish, and that I shall hold the property I get in exchange therefore. Property so relinquished does not cease to be property when it ceases to be mine, for it is my will that my donee or vendee shall hold it. The alienation of property constitutes one of the forms in which I use it, meaning the giving of it itself is a form of use. And I say, you have this. That's a form of the use of the property itself. If I want to give you a Christmas gift, I went and bought the gift. It's my property. I'm bringing it home. It's in the car. And then my will is part of the use of me being able to give it to you. So, okay, to continue, in which it serves my purpose and in which I realize my will. Again, realize my will. It's just all about you having control of your own will. Now, there's a word here that people might not understand or they might get confused about, and that's alienation. So I'm going to pull up a document, which I grabbed a few words out of, and I knew this was going to be the first one, so I popped it in. This is out of Bouvier, so this vocabulary list I will put into the show notes. So what is alienate? Okay. It is a generic term applicable to, I got to probably make this a little bit bigger so everybody can read it. Blow this up a little bit. Okay. So alienate. This is a generic term applicable to the various methods of transferring property from one to another. Lord Coke says, alien cometh of the verb alienate. That is, I'm not even going to bother to read all that Latin. These methods vary according to the nature of the property to be conveyed and the particular object the conveyance is designed to accomplish. It has been held that under a prohibition to alienate, long leases are comprehended. Alienation estates. Alienation is an act whereby one man transfers the property and possession of lands, tenements, or other things to another. It is commonly applied to lands or tenements as to alien, that is, to convey, land and fee in mortmain. And this is land and fee, comma, in mortmain. That means, and in mortmain, because you can do it. If you do it in mortmain, well, I don't want to get into that right now. I'll do a whole class on uses and mortmain and the statute of uses, the statute of mortmain, the statute of estates, all of these older English statutes at some other time. But for now, we'll just keep going through this because everything connects back in as to what they're doing. But anyway, all right. Definition 2: alienations may be made by deed, by matter of record, and by devise. Alienations by deed may be made by original or primary conveyances, which are those by means of which the benefit or estate is created or first arises. Okay. What does that mean? Of which the benefit or estate is created or first arises. You can create an estate in something at any time, because what is an estate? An estate is an aspect of your capacity of use and ownership. The substantive definition of the word estate is basically everything that a man owns in law. Now, since I'm harping on this, I might as well just go and show you guys, just to get this clear. So let's go look up estate real fast. Estate. This word has several meanings. In its most extensive sense, or actually, you know what? Hold on. This is what I'm going to do. I'm going to grab, because I know this goes on for a while. The definition of estate is quite lengthy. I'm not going to read all this, but you can see how ridiculously long the definition of estate is. It goes on. It has 57 entries. Right? So you think you know what the word estate means? I promise you don't. Because when I first read all 57, I thought to myself, oh my God, I have no idea what this word actually meant. Okay, but I'm just going to scroll up to the top. We'll just go through the first few of them, because a lot of these entries have to do with specific laws of specific states in the Union regarding estates. That's why there's so many entries in there. But to read them is very interesting, because it gives you an idea as to probate law and a basic aspect of uniformity between the states as far as the transfer of an estate. But anyway, okay, this word has several meanings. In its most extensive sense, it is applied to signify everything of which riches or fortune may consist, and includes personal and real property. Hence, we say personal estate, real estate. Okay, so that is, in its most extensive sense, everything of which riches or fortune may consist, and includes personal and real property. So all of it, everything that you own. In its more limited sense, the word estate is applied to lands. It is also applied in two senses. The first describes or points out the land itself without ascertaining the extent or nature of the interest therein, as in my estate at A. The second, which is the proper and technical meaning of estate, is the degree, quantity, nature, and extent of interest which one has in real property, as in an estate in fee, or estate in years, or estate in fee tail. These are all just different aspects of fee. And again, when I do the class about the aspects of statute of uses, all of this will be explained in more detail. But just to kind of leave it at that, well, I guess maybe I'll do, hold on here. In Latin, it is called status. It signifies the condition or circumstance in which the owner stands in regards to his property. Okay, so know that. This aspect that in Latin, it is called status. Literally, your estate is your status. And I know these things are kind of intermixing and they intertwine. It's because the words go back so far, and they are based in Latin. And then they get morphed and they get changed and they get added onto as we, do with language. And so it gets a little bit confusing. But that's why I wanted to bring out Bouvier's and wanted to make sure that everybody reads this to get it through their head as to what estate is. Okay, estates and land may be considered in a fourfold view with regard to 1, the quality of interest which the tenant has in the tenement; 2, the time during which that quantity of interest is to be enjoyed; 3, the number and connection. I don't know if it's coection. I don't know if that's a misprint or that is misspelled. I don't know. Number and connection of tenants. 4, what conditions may be annexed to the estate. So things can be annexed to an estate. But annexation also in land is to say to annex more land around you, or to take that which might be abandoned, right? Again, the aspect of adverse possession, that's another aspect of it. So we have, so the idea of an estate is the amount of interest that you have in something. It can also be considered an area of land. It is also considered literally your status, right? It's called status. That's the aspect of Latin because that's where it stems from. So all of these things are true at the same time. So that's why this can get a little bit confusing when you start reading things like a treatise like this. So now I'll go back to the treatise. So now we know what alienation is. Wait, hold on. That's why we needed to pause back. So I'm going to go back and go back to alienation here to make sure that we know what this is, because I paused at estate. So scroll back up here and finish off with alienation. Then we'll go back to the treatise. Okay. So alienation, estates. So now that we know what estate is, now we can come back to alienation and understand what this means. Alienation is an act whereby one man transfers the property and possession of lands, tenements, or other things to another. It is commonly applied to lands or tenements as to alien, that is, to convey. So if I alien something, I'm conveying it. And alienation is obviously that process in land, fee, or in mortmain. Alienations may be made by deed or matter of record and by device. Alienations by deed may be made by original or primary conveyances, which are those by means of which the benefit or estate is created or first arises. By derivation or secondary conveyances, by which the benefit or estate originally created is enlarged, right? Remember I said as something was annexed, possibly, right? So that's an enlargement of the estate. Restrained, meaning no, you can't have that. Transferred, meaning you have it now. Or extinguished, meaning the whole thing went up in flames and it's gone. Or the whole claim is completely abandoned. These are conveyances by the common law. To these may be added some conveyances which derive their force and operation from the statute of uses. Okay, this is why I'm going to do a class on the statute of uses later. But what they're referring to from the statute of uses, it's the English statute. This is not an American statute of uses, even though, well, let me back up here for a second. There are statutes of uses that are in America for American jurisprudence, but what they are referring to here is the English statute of uses, okay, which was passed in England. I don't recall what date exactly, but they're part of the statutes of Westminster. So, all right. So the original conveyances are the following: feoffment, gift, grant, lease, exchange, partition, the derivative are, and these get really confusing. So I don't even know if I want to go through this because it might confuse some people. But basically, these are all different ways to transfer or to have alienation or to alien something to someone else. But in the statute of uses, it gets into all this stuff about the different amount of or the types of fee, right? So anyway, so I'm not going to bother with all that, but that's just what it is. These are the different types of ways of transferring by alienation. Okay. And then down here, just last one, the term alienation or mental alienation is a generic expression to express the different kinds of aberrations of human understanding. Okay. So now that we have alienation out of the way, now we can go back to the treatise. Okay. So, and just to remind ourselves what we're doing here. So we're talking about alienability of property. Property so does not cease to be property when it ceases to be mine, will that my donee or vendee shall hold it. The alienation of property constitutes one of the forms in which I use it, in which it serves my purpose, in which I realize my will. This phrase or quality of property constitutes a sphere of contract. Alienability is one of the essence of property. An infringement of my right or power to alienate my property is therefore a limitation upon my free will, and to that extent, a violation of my personal liberty, because my free will finds realization in property. The infraction of my personal freedom is precisely the same if a limitation is put upon my power to alienate property as if I were prevented from acquiring or from holding or using it. So you can have someone commit a trespass upon you by them not allowing you to get rid of a thing. Now, that's a rather odd way of thinking about that, but that's exactly what that just said, because it's an infraction upon my personal freedom. Now, what have they done? Well, I'll get into the whole system in a bit. I want to cover a few more things, and then I'll kind of bounce back into what they've done at the foundling hospitals. Okay, so subsection 4, operation of the owner's will after his death. Now, this is talking about a final will and testament. Okay, property then is the realization of the free will of a person, the external sphere of his freedom. As such, it partakes of and is clothed with the dignity and inviolability of the person. The things which constitute property can have no rights, for they have no will. And will alone, or the person in which it has its abode and vehicle, can be the subject of right and of its correlative duty. The law recognizes and deals with property only insofar as it recognizes and deals with the will of the owner, realized or externalized therein. For the sphere of law is the spiritual. It operates upon through the will alone. Get that. I'm going to reread that again. For the sphere of the law is the spiritual. It operates upon and through the will alone. And anybody want to recall what William the Conqueror did in 1066, but William the Conqueror came over England in 1066, and one of the things he did was he separated the spiritual and temporal courts. And he gave the power to his filthy priests of El, cult of Rome, if you will, or what was left over of them, gave them the power over the property of the dead. And eventually that's what became what we now know as probate. So just understand that there's for the sphere of law is the spiritual. It operates upon and through the will alone. Thus, the law recognizes in the property of a deceased person his free will, that is, his rational will, and enforces it. Now I'm going to read these two down here. Okay, so intellectual or manual skill, sciences, arts, even religions, functions, sermons, masses, prayers, etc., as well as services to be rendered for another at or for a given period, are all included in the sphere of contract. Okay, so again, let's connect contract with the aspect of free will and the creation of law itself. There's a maxim of law that states the contract creates the law. And it does, because two people come together and they choose what the law is between them. They write it down, they sign it, they seal it, and one delivers the other executed contract to the other, and they have then just created law between them. That's what you do every single time with a contract. You create and write law. What have I done with the vocational science freedom status doc set? I have created and written law in the form of a contract, particularly under the KW. And when someone else comes upon you and decides to administer your estate against your will, they then activate that contract. And they then agree to be trustees of your estate. It is no different than a user and license agreement in regards to software. When you use software, you agree to the user and license agreement. And in the user and license agreement, guess what? There's an arbitration clause. Well, I just did the same thing, but I reversed engineer it for the protection of our entire estate. To say, look, if you're going to continue to administer my estate, any part of it, of which I have now claimed, and of which there is no presumption of abandonment or any other status which would reduce my capacity over it. When you go and administer it, you've now done so against my will, but by the will of your own. So therefore, you have willfully entered into contract. That's what we do. That was the reason why I wrote everything the way I wrote it, to make sure that there was no way out of it for them. Because all I did was I reversed engineered everything that they've been doing to us for the past 100 years. Because I'm sick and tired of them constantly coming in and saying, oh, we can do this and we can do that to your states. We can do this to your states. No. You're not doing anything to any of our estates anymore. We're done with you. Enough's enough. So that's why I had to do what I had to do and why I wrote it the way I wrote it. So over here to continue. All right. So it may appear on superficial view that such skill or function or services cannot be classed as things and do not therefore constitute property, being themselves emanations of free will, the qualities or attributes of the mind. But it is within the province of my mind or will to externalize a limited share of my activity to give to another an interest in it, and thus to reduce it to the condition of an external thing, which I may alienate for his use. Not the whole of my labor, skill, or services, the totality of my activity or productions. For that would be to alienate my own personality, to destroy my will, which are inalienable. So what that paragraph was just describing, or that sentence was just describing, was saying, yes, you can alienate certain aspects and certain things, but not the whole of my labor, skill, or services, the totality of my activity or productions. Right? Because that would then be to alienate my personality. And therefore you would then be a slave. And that is unlawful. And that is why that is inalienable. Cannot do that. And if someone tries to do that against you, that's a crime. And that's exactly the reason why we say our inalienable rights. Why that word is used in the Declaration of Independence and all the other foundational documents of which it is used. That's the point. All right, to continue. The servant or laborer for his hire realizes his will by exchanging his services or productions for his wages, and thus enters into a lawful contract. But the slave gives up or is deprived of his free will to the destruction of his personality, which can neither be relinquished nor acquired as property by another. And yet that is exactly what the attorney, the Luciferian Khazarian mob, has done to all of us. They have stolen all of our wills. They have made of us slaves. And it is about time we all wake the fuck up as to what they are doing. Realize what they've done, learn it, see it for what it is, and then teach it to your fellow American. Or if you like, just send them these classes and say, you need to learn this. Your very personality depends upon it. And they'll say, what? My personality? And they'll say, what are you talking about? that my personality doesn't depend on anything that I haven't seen yet. And you'll say to them calmly, oh, yes, it does. And you do not yet understand why. So, number 2, the will is free. Freedom is its substance and essential quality. In the like manner as the substance and essential quality of matter is gravity. Gravity is not an accidental predicate of matter, but matter itself. So with freedom and will. Freedom is will. Will without freedom is a word void of meaning. Freedom exists only as will. Okay? Got it? Back to here. Back to the spiritual. So now I'll reread this again. For the sphere of law is the spiritual. It operates upon and through the will alone. Thus, the law recognizes in the property of a deceased person his free will, that is, his rational will, and enforces it. The failure of such recognition would destroy the property, which can be such only through the will of its owner. If this has been adequately expressed, the deposition of the property is enforced accordingly. If not, the law itself supplies the omission by imparting to the property the universal will, which is the free will of rational persons. All right, I think I'm going to skip section 5 because this is the difference between rational and capricious will. That's basically all this section is saying, is that that it must follow the law to be a rational will and must ignore and cancel that which is capricious and arbitrary. But, in a sense, what they're doing to us in these inferior courts not of record is exactly that. It is capricious and arbitrary. But anyway. All right, section 6, relation of property to the family. The ethical relation between the sexes demands their union in matrimony, from which the family results as a spontaneous, natural, social union, society. That's right. Your family is your society. Your house is what protects that society, both figuratively, spiritually, and legally. So those members are united by the bonds of mutual affection, implicit trust, and voluntary obedience. The family is an organic totality whose constituent elements have their true existence not in their individuality, but in their relation to each other through the totality, lacking independence when separated from it. They have no separate interest to seek, but only one common interest for the whole. Hence, there dwells in the family but one will, namely that of the head of the family, who represents it in its legal relations to others. Do you now understand why it's so important to lay down and create your own house and your own seal for your own house, and that it is the paterfamilias of the house that does that, if indeed there is a family? If it's a single female, then it's just then she is the materfamilias of her own house, or usually the house of her father, because that would be the name that she would have. So she would be of the house of her father. But if her father never established a proper seal and a proper house, she has the right to do that, because it is something that is alienable to her, came from her father. And until she enters the house of another man, she can have her own house. But if you are already in a family, then this applies. Hence, there dwells in the family but one, namely that the head of the family, who represents it in its legal relations to others. In recognizing the true nature and validity of the family, the law accords to it and secures it in the enjoyment of the necessary means to its existence. Property. And this, in a higher sense, and in a more efficient degree, that it secures the property of individuals. The existence of the family is an aggregate person, requires a permanent estate. Remember that. Okay, so what is the estate of the family? It is the house. It's everything that is under and in control of the house. And the house is the invisible, lawful creation. It's like a boundary of law around all of which is protected or under or in the family. So the existence of the family as an aggregate person requires a permanent estate. Adequate not only to the capricious purpose and desires of an individual, but to the common collective wants of all its members. In this estate or property, no one member of the family has an exclusive interest or right of possession, but each his undivided interest in the common fund. That means like the wherewithal, the health of the family, everybody, how your household is being run, right? If you're on a homestead, how the homestead's being run, that's the all of this encompassed and also a full aspect of that, right? Okay, so nevertheless, the property is usually held by the head of the family and in his name. It devolves chiefly upon him to provide for it the means of subsistence, and of satisfying their various wants. He controls, manages, and disposes of the property or estate limited in his absolute dominion over it. Again, this is important, and this is an aspect of law. So sorry, any left-wing feminists that might ever listen to this. Tough shit. This is what the law says. He controls, manages, disposes of the property or estate limited in his absolute dominion over it, aside from his moral obligations, only by the affirmation provisions of the law, meaning he can't overly harm anything or destroy anything that would harm another individual in the family, right? So upon the dissolution of the family through the development of its ethical purpose, i.e., upon the attainment of majority of the children, who then separate from it as persons sui juris, which means of your own mental capacity, that you're of capable mental capacity. That's what sui juris means. Capable of holding property of their own and becoming founders of new families. And I would continue this, even founders of new houses if they wished. But their interest in the family estate is modified accordingly. The authority of their father, as well as his liability to support such children, is no longer recognized in law, but becomes of ethical or moral force only. Right? So let's skip down to 8 here. So succession of property at law. Upon the natural dissolution of the family by the death of the parents, or more particularly, the husband or father, the property of the family descends to the heirs. Okay? Descends by descent. How does an heir get something? By descent. So estates and families and living beings have heirs. Corporations and fictions of law, they have not heirs, but successors. Just remember that. There's a huge difference between, obviously, the fictional side and the truthful side, because there's a maximum of law that states where truth exists, fiction of law cannot exist. So these two separate systems, the side of the living and the side of the dead, never shall the two may meet, honestly, is truth be told what should be happening or how the law should work, until the time of which one's last will and testament be executed. But again, that's still, technically, his last will when he was living. So it's still dealing with the living, not the dead, which is what the ecclesiastics would like you to believe. But anyway, so I'm digressing a little bit. All right, back to this. Okay, it is quite apparent that in the case of a family in the most restricted natural sense, consisting of parents and children, there is in this process no substantial, but only a formal charge of ownership. The property held by them in common, or by the head of the family for them, now passes to them directly. In the absence of a testamentary division, the property vests by the law of descent, passing from the husband and father to the wife and children, that being the natural, substantial, and rational course, such as in the absence of contrary disposition, in the rational substantial will of the deceased, to which the law gives effect. Obviously, one's last, one testament. In default of wife or children, the parents, brothers or sisters, or other more distant relatives constitute the heirs. The family bond is looser as the kinship is more remote and the relatives belong to other families of their own. In the same ratio in which the reason demanding the heirship between members of the same family loses force with the remoteness of kinship, the propriety and justice of testamentary disposition of property becomes more apparent. The disposition of property in anticipation of death, dono moris causa, is but another form of testamentary disposition, meaning things that you'd give away before you actually died to just people. Okay. So with that, I'll pause here. I'll make a sticky note so we know that we're on subsection 9. So we're left off here. So we'll leave it there. Are there any questions that anybody had that you'd like to put into chat and or would like to unmute yourself and ask live? And if not, then I'd like to thank you all for coming. And if you'd enjoyed this presentation, please like and subscribe to the Vocational Science Freedom YouTube page, and specifically on Odyssey, because there are certain classes that we can only post on Odyssey and not on YouTube. And the next class, we'll be doing a on and off week schedule for all of 2023. So in case anybody doesn't know this, we're going to be doing, each week will vary between a civics and sovereignty class on Saturday, and then the next week will be a open roundtable, and then the next week we'll go back to civics and sovereignty. So we'll be alternating back and forth between Wednesdays and Saturdays for the rest of 2023. So I'll see you guys next Wednesday then, which would be the 8th for the open roundtable, and we'll figure out what we're going to discuss at that time. Until that time, I hope all of you have a wonderful rest of your weekend, and stay safe and stay sovereign.